Afternoon, everybody. Chris Gant Sorensen with Hansler Sinclair Boyd and Perry McClendon here, Keely Yates here, and we're looking forward to being with you today, hoping we can provide some useful information to you, give you a platform to ask us questions. We figure by now you're well into COVID-19 compliance and you're dealing with a number of issues at the workplace. Perry and I are certainly getting calls from a lot of you indicating that you've got a lot of issues going on at the workplace, dealing with exposures, the leave issues. And so we're hoping to address some of those. And we would encourage you as we go to please put your questions in the chat room. We try to discuss the ones we think everybody would benefit from publicly. And we're trying to give you today more space to do that. But before we get into it, if you'll note, I'm calling you from a very isolated, deserted, remote island, far, far away in the Virgin Islands, and it of course has all this white sand that I'm sitting out on and this beautiful turquoise water. So I hope you'll be able to hear me all the way from this very, very remote island. Ha ha ha, right? It's July. I don't know about y'all, but we are all probably starting to be frustrated about not getting a break. All of you, I know, because a lot of you have been with us all the way through this, starting early March, we have been running hard. And I know how stressful the HR world is trying to keep up with all of this and then deal with all the HR issues as well as managers and owners and executives. And so we could all use a break about now. So I hope you'll not forgive me, or I hope you'll forgive me for wanting to come to you from a remote island rather than the state office environment. We're going to send you around a poll. Keely's going to send it, and we're going to pretend like COVID-19 is not a reality and we're all about to take a vacation. So if you could go anywhere right now that you wanted, where would you go? Choose, and we'll let you know what the poll was. In the meantime, while you're doing the poll, make sure that you know how to operate our Q&A chat. Put your questions in there. That's been going really well. We do try to cover all of the questions during the webinar, either in our responses on the chat box or publicly. So be sure you're also looking at the chat box for our responses, as the information is helpful usually to more than just the person asking the question. We will provide, as usual, our slides to all of the attendees, and we'll also post our webinar on the HSB's COVID-19 webpage. I would encourage you to actually go on that webpage. All of the things that the employment law team has been doing are, of course, there, but we have them from all of our other departments, and there's a lot of information that's going to be of assistance to all employers and businesses, not just human resource professionals, on that page. And then finally, there is credit for attending this. You still have to meet your HRCIs and your SHRM requirements. We have to still meet our CLEs. And so make sure that you follow up with Keely afterwards to get what you're getting from us. I would also add now that I've got some great news to share with you about Perry that I just know he would not be comfortable sharing. In fact, I had to twist his arm and get Keely's vote to do so. Perry has been awarded by the American Bar Association this year with the Rising Stars Award. There's top 40 lawyers to look for, to keep your eye on the rise in the nation, and he is one of them. So we are so excited about this. And it's just evidence that Perry is a great resource and able to help lawyers and human resource professionals as they navigate employment law. And we're just very proud of Perry. Additionally, on top of getting that award, Perry and his wife, who they also had a daughter, and her name is Syl, short for Lucille, which is Perry's grandmother's name. And absolutely beautiful young woman, and she is gaining weight. She was born a little early. I'd say, Perry, how old is Syl?
She was 1 month as of Sunday.
So Perry kills me. I'll have to tell you, I kept thinking I was kind of trying to leave Perry alone. And Perry still manages to be on top of everything, and I'm certain is being a good dad to Syl. So congratulations, Perry.
Thanks.
All right, the poll is in. 35% of you would go to the beach. 29% of you would go to the mountains. 8% of you would go to Disney World or amusement park, and 29% of you would go to international travel. I would definitely pick international travel, and more specifically, something that looks like this. What about you, Perry?
I'd probably go to the mountains or maybe international travel. Those of you who voted for Disney World amusement park are very brave. I would not be anywhere near an amusement park.
That's right. All right. Well, thank you everybody for participating in the poll. And now Perry's going to get us on track for our serious conversations and discussions today.
All right. Thank you, Chris. Welcome everybody. Thanks for the nice congratulatory comments in the Q&A box. We sent out a survey to those of you who normally attend these to see what you were interested in hearing about, and we had about half of you respond saying that you're still interested in hearing about COVID topics, and then about half of you said you were starting to get tired of COVID. So that's probably about right. That's probably where Chris and I am with it as well. So we're going to try to do a little bit of both today. We're going to still mostly talk about COVID, but we're going to touch on some other issues, and hopefully gradually as these go on over the coming weeks and months, we can hopefully, fingers crossed, start to cover less about COVID, because I think a lot of you have your arms wrapped around the COVID situation pretty well, although things are still changing. So we're going to give just an update on COVID, some new DHEC guidance that we got. Chris is going to talk about contact tracing, which I think is probably the trickiest part of DHEC's new guidance, and figuring that out for your workplace. Brief update on litigation, and then a legislative update, both in South Carolina and at the federal level as well, because we do have some non-COVID related employment law news to share. So as far as COVID goes, this is a snapshot I took from the state newspaper. This was as of Monday, I believe, with over 44,000 confirmed cases, 820 deaths. South Carolina has seen a spike in cases. I think that's due to both an increase in testing as well as probably a true spike in spread due to people getting back to work, more people going out in public. Unfortunately, still a lot of people not wearing masks out in public, things like that. And so things were looking good for a while, and I was kind of hoping by this point in the summer we would have gotten a handle on this a little bit better, but we haven't. Dr. Fauci says that this is not a second wave, that we're still knee deep in the first phase of this, which is a little bit scary. And so health experts are predicting for, another spike in the fall. And this is probably going to continue to be a really difficult issue, particularly as we, maintain the economy, potentially open schools back up, open restaurants and things like that. Until we get a vaccine, this is probably going to be a very new reality for the workplace, and COVID is going to become something like everything else that you have to deal with, and just a part of your daily activity as an HR professional until we get that vaccine. So a lot of different considerations with this in mind. We've sort of gone through a few different phases of this. Anecdotally, I'm seeing a lot more calls and questions from clients now about positive cases. A much larger percentage of my clients have now have positive cases, or contact, some kind of interaction with somebody that's positive. And so there's a lot less questions about the FFCRA and a lot less questions about PPE and things like that. And now we've moved into do we need to shut down our business because of multiple positive cases? Who do we need to send home? Who do we not need to send home? Those types of questions are the ones we're mostly getting now. Dealing with this for the rest of the summer and the fall, there's going to, I imagine, continue to be tough business decisions that need to be made. I'm still hearing from a lot of clients that demand is down. some of my hospitality sector clients certainly are feeling the hit. Some of the manufacturing sector as well is seeing a decrease in demand. So I think there's probably going to be continued difficult decisions about layoffs and reduced compensation and things of that nature. I think one key issue to, and Keely, you can advance the slides to the next one. I think one key issue that everybody is probably going to have to deal with on an increasing basis is this issue of schools potentially being closed. As of right now, I mean, I think South Carolina is probably going to open all of their schools, but that still remains to be seen. I know some states are not doing that. And so I think for the foreseeable future, you're going to continue to have increased requests for leave, and increased requests for work from home solutions. And that's even setting aside the FFCRA. Even if an employee has used up all of their leave or are not eligible for whatever reason, or you don't have to comply, I think employees are increasingly asking for flexibility. And I think you are going to, in the COVID world and even in the post-COVID world, I think you're going to have to be increasingly flexible to the extent that your business operations can allow it. Obviously, there are certain jobs that you have to be in the office to perform. For those other jobs, I think it might be good from both a liability standpoint and a recruitment perk standpoint to be able to offer some of those flex time, remote work solutions and things like that. So I've had a lot of questions from clients the last couple of weeks about how to deal with that, and have developed a few work from home telecommuting policies that businesses are telling me they're going to implement even when the COVID situation settles down. So where do we stand on restrictions? Nothing has really changed over the last few weeks. There have been calls we do have mask ordinances in some jurisdictions, and those are you could have issues with those with your employees and with your customers. But for the most part, businesses are still open and are still allowed to be open. And even if you have positive COVID cases among your workforce, you are generally still allowed to remain open. Most of the businesses have brought back most of their employees at this point in time, but some are still furloughed. The biggest issue we're seeing is some smaller businesses with, one or two positive cases having to reclose after being opened back up. And so that's an issue we're now seeing, and safety is still probably the primary COVID concern at this point in time. All right, so one bit of new information that we received last week is some additional guidance from DHEC, which I thought was very helpful. We did a blog post about this, which you can find at scemployersblog.com, and it has a link to the DHEC guidance, which I encourage you to read. It's good. It's very digestible. It's broken out in sort of chart format. I really like the way they did it. It's a lot clearer than some of the CDC and OSHA guidance that's really hard to sort through. So I'd encourage you to download a copy of that and read that in full, but I will go over a couple of items from that guidance. It's called Interim Guidance for COVID Scenarios in Business. And what they've done is they have a graph, and they've broken it down into what to do if an employee tests positive, what to do if you have a sick employee but no positive test result, what do you do about employees that have come in close contact with a positive test, what do you do about somebody that's come into close contact with someone who's sick but no test. So all those situations, each one is a little bit different, and even each scenario within that is going to be very fact specific. But a couple of things just to highlight for you here. So one of the things that was interesting was that they put upon notice of a positive case in your workplace, HR should immediately gather the following information, which I thought was interesting. They specifically called on HR to gather information. Date of the onset of symptoms, if applicable, date and location where the test specimen was collected, date the test results were received, instructions provided by the healthcare provider when test results were communicated, and whether the employee came in close contact with any other employees or visitors from 48 hours prior to the onset of symptoms until they were sent home. And Chris is going to talk a little bit more about contact tracing and how you determine who they've been in close contact with. And then one thing on an employee who has symptoms and you know, calls you and says, I'm not feeling well, but they don't have a positive test. If the employee does not get tested, he or she should remain out of work under the same criteria, 10 days, free of fever, et cetera, as if he or she tested positive. So for that purpose, I mean, you just assume that they have tested positive for purposes of the self-quarantine. And if the employee does get tested and it comes back negative, you should still have them self-quarantine until a resolution of all the symptoms. And so those are a couple of things there. There are, I won't go through all the other scenarios because there's a good bit of information, but it does have, you know, what to do if an employee eats at a restaurant where, you know, a staff member at the restaurant tested positive, those types of things, which I think all of these are very helpful. But again, you can find the link to the DHEC guidance on our blog. And Chris, I know you're up next with contact tracing anyway, so feel free to add anything that jumped out to you from that guidance or otherwise.
All right. So this is actually a tool that I put together and have been sharing with clients so that they have this available to them when they need to quickly respond to someone who's been exposed, whether they're hopefully, luckily calling you from home and haven't reported, or if it's an exposure that they report to you at work. And so this is actually meant to be a tool. We've been getting a lot of questions about, will we get the slides? Will we get this information? Will we get the list? And again, this is going to be something that we will email to you all at the end of the presentation. The webinar, recorded webinar, will be available on HSB's site. So the very first thing is identify, and Keely, go ahead, this is a list, go ahead, notify, isolate, and monitor. Right, so you identify, if you go ahead and click to the next slide, identify means any person who meets the following criteria, and think about 6, 15, 48. So that is, who was the employee near, closer than 6 feet in the last 48 hours for 15 minutes or more. So that's who you want to ask the employee about. Who were you around where you may have been closer than 6 feet for 15 minutes or more in the last 48 hours, because 48 hours before symptoms, before an employee becomes symptomatic is the time that they're most infectious. Once you figure out who that is, then you move on to notifying the employees that may be impacted. When you notify the employees, you need to do so without ever revealing who they are. And a lot of employers are saying to me, well, of course, everybody's going to know who it is because of da-da-da. And that's one thing, but it can't come from your mouth. It can't come from the employer's mouth. It can't come from anybody that's in official capacity, management capacity. And so just say you may have been possibly exposed to the coronavirus, and we would like to refer you to the South Carolina Free Telehealth providers. This should be something that is in your policy, linked in your COVID-19 policy. And we would want you to follow up with them and see what they would have you do, or follow up with your own provider and see what your own provider would have you do. And then we would also want you to monitor For any symptoms that you might develop, we would want you to exercise all of the hygiene projects that we're talking about, and make sure that you are quickly alerting to us if you develop any of the symptoms. Again, your policy should list all the symptoms. Now, if you're keeping up with this, CDC keeps adding symptoms. And so there are new symptoms as of a couple of weeks ago. So make sure that your policy is updated to include the new symptoms. Now, if you have someone who, let's stay on the prior slide, sorry, who is hard of hearing or deaf, make sure that you're communicating with them in a way that is going to work for them. Of course, don't forget to do that. And also consider talking to the folks that you know are high risk without mentioning why you are talking to them first. Try to talk to them first and alert them first. All right, thank you. Next slide. All right, so then you need to, of course, isolate employees who had close contact with the infected employee if you can. Now, this is harder. This is harder. And it depends on what your workplace is, but I've had some employers who were able to have the employee who may have infected work to where they were already distanced or were in a different area which would permit them to be distanced. If there's a way to send them home and let them telework, great idea. But if you can't send them home, is there a way to distance them? You've got to worry still about, the common areas and such, and I would recommend stepping up your cleaning in those areas, and that should be part of what you analyze as far as the employee who became infected as well as the employees who may have been infected. Which common areas do you use? Which ingress egress door do you use? Which bathroom do you use? Which kitchen do you use? Make sure you're asking all those things and maybe stepping up the cleaning process during that time. So I know that CDC, DHEC, and all of the guidance we see says that we've got to isolate the people who may have been in close contact with the person who had the exposure. And here's what I'm going to say to you. That's easier said than done. I know you may or may not be able to actually do that. If it's a situation where they're not going to be able to maintain social distance with all the other employees, but they absolutely have to stay at work, I would recommend that you consider having them wear a mask at all times if you don't already have that policy. So have that employee, of course, monitor their, symptoms and keep up with the symptoms, and notify you immediately if they become exposed. Next slide. About the monitor. So the employee who's ill, there's a lot of discussion about that. An employee who is ill or an employee who is not symptomatic, if you are sending your employees home that may have been exposed, then they can return after 14 days of becoming asymptomatic. These are CDC guidelines. This contact tracing tool, it was developed with CDC guidelines. DHEC's guidelines are stricter. DHEC even has a 17-day period for someone who has had coronavirus or been tested as having coronavirus. So I mention that now because there's a contradiction in that guidance, and of course, South Carolina employers are going to be responsible for DHEC. Perry, do you have any thoughts about that you would add?
No, I think the DHEC guidance is it is a little bit stricter, but I think it's wise to follow that. I mean, I think if you get into a situation where you've got litigation in South Carolina over this, I think both plaintiffs, lawyers, as well as judges are going to be looking at that DHEC guidance as really the word at this point in time. So if you don't follow it, it's probably going to be somebody's going to try to use it against you.
I think that's well said. All right. Thank you. Next slide.
All right. So in the last presentation we gave, I went over some of the specific cases that are out there. COVID litigation has been a big concern among businesses and has been attempted to be addressed through legislation at the state level. I've done a bit of research on sort of where things stand with litigation, and from what I can tell, over 250 complaints filed against businesses across the country by employees, 4 of those in South Carolina that we know about. There's probably a lot more at this point in time. Those are basically ones that have been reported by the Post and Courier or the state newspaper and have sort of received attention. But I didn't sort of pour through every court filing to see what has been filed, but they're definitely out there. For every lawsuit, there's another, 10 sort of pre-lawsuit negotiations with employees that are going on. I've had a few of those with my clients, negotiation of separation agreements, and things like that. And so there's definitely a fair amount of litigation and tension out there with employees. Class action lawsuits are something that has been receiving a fair amount of attention. So a class action lawsuit is basically a lawsuit by more than one person, a group of people all alleging the same thing. So a group of 20 of your workers alleging that you didn't provide them with PPE, or a group of 30 employees saying that you unlawfully reduced their wages or enacted a wrongful FFCRA policy or something like that. Those are particularly difficult to defend, particularly expensive. Typically, they're a lot more high profile. They're probably going to end up in the newspaper. So just something to keep an eye on, particularly when you take action that affects a large group of people. That you want to make sure that that's done in a correct manner. Obviously, you want to do that for any situation, but the sort of one-off employee situations are a little bit easier to deal with than if you're, reducing compensation or changing classification of 20 employees. A lot of the class actions that we see are wage and hour class actions. So people alleging that they weren't paid overtime or something like that. So just something to highlight and keep in mind. As far as the types of cases that are being filed, we are still seeing the majority of those cases be FFCRA. So that's the Families First Coronavirus Response Act. That's the federal paid leave law that we've been over several times on this. And I'm still getting questions about it, mostly related to employees who have taken full advantage of the 12 weeks and now are not coming back, or are sending emails saying, I'm not comfortable coming back, or I can't come back, or whatever the case may be. Can you separate employment with those individuals? If so, how do you do that legally? So those are interesting. Those are interesting topics, and I think that's an area where we're going to see some increase in litigation. In addition to the FFCRA, discrimination complaints, safety, both PPE and requiring people to come to work, and as well as wage and hour, all fall in there as well. And sometimes you see multiple of these allegations made in the same lawsuit. One thing I wanted to point out, I've seen a real increase in social media related employment issues. A few of the lawsuits that we've seen filed have had some kind of social media component. And we've even seen one or two cases where a business sued a former employee for statements made after the employee was terminated, and the employee took to social media bad-mouthing the company. And the current environment that we're in, it seems a lot of people are a lot of people are not afraid to express their beliefs on social media, whether it's, in regards to political issues or, outing their employer for not, taking safety precautions, or, ranting about a decrease in compensation, or whatever the case may be. People seem to be using the social media public forum to air grievances with their business. And several lawsuits have alleged that. You've got to be especially careful if you've got a situation like that. If you've got an employee posting on social media something that you don't like, and you want to talk with that employee about it, discipline them, fire them, you've got a former employee who's out there doing that, I would really encourage you to to talk with legal counsel about that. There's a very fine line between something that an employee posts that's protected and they cannot be fired for or disciplined for under the National Labor Relations Act. Things like complaints about safety in the workplace, whistleblower protections, things like reductions in compensation. Those things are legally protected, but false statements about a business, statements that disparage the business that don't fall within that could be, you can fire somebody over that. And so be particularly careful with those, and we're definitely seeing an increase in them. Just following up on that, best practices to avoid getting yourself into a litigation situation. I've had a lot of clients reach out to me wanting to create, strict policies for how they're going to deal with people coming back from FFCRA leave. And they want to create a policy that says, if the person doesn't show up on the day they're supposed to be back, they're automatically fired, and this type of thing. I would caution you to try to analyze things on a case-by-case basis. I think the law requires you to do that, but the FFCRA, as well as considering the FMLA and the ADA and other potential legal avenues an employee might have to protected leave, you do not want to get yourself in a lawsuit because an employee was supposed to return to work on Monday and they've sent you a text saying, hey, can I have until Wednesday? There needs to be some measure of flexibility in there. There needs to be some open communication and conversations with the employees about why they can't come back to work. Is it a medical issue that they can't come back to work for? Is it a childcare related issue? Is it something that you can work something out for? Is it an employee just trying to take advantage of the unemployment system? You really need to dig into what the issue is and not just sort of create a blanket policy of how you're going to treat all these employees. I think most of you probably have a safety plan in place at this point in time. If you do not, please reach out to us. I think that is a minimum of what you need to have in place, a written safety plan that incorporates the DHEC guidelines that we went over today. Again, I'll mention this, think carefully before terminating really any employee in this environment. There's some cut and dry, easy cases as always, but I think in the current environment that we're in, that there seem to be a lot more tricky termination issues. And then finally, just keep in mind with COVID negligence law, which is failure to act reasonable under the circumstances. And so if you get lawsuits from third parties or potentially employees in some narrow situations, customers, things like that, they're going to be alleging, if they're injured, they're going to be alleging that the business did not act reasonably under the circumstances. So what does it mean to be acting reasonably in COVID? Well, creating a written safety plan, following DHEC guidelines, being flexible with employees about leave requests. All those types of things are evidence of reasonableness. Providing personal protective equipment. All those are evidence of reasonableness. And so just keep that in mind as well. And then, Chris, did you want to add something?
Yes, just real quickly. I wanted to address Tracy Lilly's question. I thought it was a good one, and it's applicable to FFCRA leave. I thought this would be a good time. Great question. Greenville County School System is offering parents the opportunity to voluntarily have their child participate in the new full-time virtual learning option instead of classroom-style learning. If a parent elects that, they should not be eligible for FFCRA for school closure because the school is not closed, offers on-site classes, but the parent elected for virtual learning option, correct. I agree, Tracy. I do not think that employee would be eligible for the EFMLA leave under FFCRA. The quandary comes in how you deal with it if the parent has a student who has a disability, and that is a student who might qualify for the definition of associative disability. So you would want to be careful with that, but that doesn't necessarily mean that they're entitled to the FFCRA paid leave. They just have to use their own leave, but you'd have to make sure that you're not discriminating against them on the basis of their child's disability. Perry, would you have anything you'd want to add to that?
That's exactly what I was going to say. I think going back to my earlier point, if someone requests leave for that, I think you need to have a conversation about why. And if it's okay, we like this virtual learning option because it's easier for us, they're not entitled to any leave for that. But if it's some medical related reason, I think you need to have, I think you need to be careful to avoid any kind of, disability discrimination claim. But for the most part, I think, as long as the school's offering an on-site, option and they're not closed, then, and employees elect to do a virtual option, then, they've got to come into work and as normal and would not be entitled to leave. So that's a great question, though. I had not realized that some schools were offering that as an option. So that's very good to know. Great question. All right. Quickly, a legislative update, and I think we can open it up to any additional discussion points or questions. We left a little bit of time at the end of this. Where do things stand? There's a fair amount been going on in the employment law world, but maybe we'll touch quickly on COVID-related stuff first. So the South Carolina General Assembly had two different bills floating around about liability protection for businesses that were reopening during the pandemic. Unfortunately, the General Assembly did not pass anything, so nothing good to report there. Apparently, the General Assembly is coming back in the fall. I don't know if that's for a limited session or what, but I know the South Carolina Chamber of Commerce is really going to be making another big push for some liability protection. Some states like North Carolina have passed something, so a little bit disappointing that South Carolina did not, but remains to be seen. I don't think the door is completely shut on that until we see what happens in the next session. At the federal government level, there was an extension of the PPP program. There's still some money available if you did not receive a PPP loan. This is not funds that are available for a second loan if you already received one, but if you have not received one and think you might be a good candidate for it, and I think most businesses are, then that's something you may want to consider. There all kinds of talk on the news channels about additional stimulus measures, additional protections for businesses, additional protections for employees whose schools are closed, all kinds of stuff. Nothing that's sort of really at the level of being close to being passed. So I don't think there's really anything to update there, but we'll keep everybody posted through our blog. Unemployment. Again, there's been a lot of talk back and forth about extending the unemployment benefits. There's been specifically talk about doing it for certain sectors and passing a stimulus measure specifically towards the hospitality industry and things like that. Again, we'll keep you posted through the blog, but nothing new to report there. One more thing on my end, and I'll turn it over to Chris. And I think that sort of concludes the COVID-related legislation. The South Carolina General Assembly did pass a new state employment law the Lactation Support Act, which we also did a blog post on. You can check out. This was another big initiative and push of South Carolina WREN, which is the Women's Rights and Empowerment Network. They have become quite a powerful lobbying arm in Columbia for protections for working mothers in the workplace. They have been very successful at getting state legislation passed that provides protections for employees, which for years we did not really see anything at the state level as far as employment law. So again, this is another victory for them and for working mothers as far as workplace protections go. Basically, the Lactation Support Act has a couple of different provisions, which I'll go over quickly. First of all, just as a very basic premise, it prohibits employers from discriminating against those mothers who want to lactate, express breast milk in the workplace. That was probably already protected under federal law for sex discrimination, but they've made that clear in this law. An employee could file a complaint with the Human Affairs Commission and file a state law cause of action for it now. It's also a big statement of intent from the General Assembly that this is something that they take very seriously, and I think the courts will take very seriously as well. Probably more importantly, the law requires that employers take reasonable steps to provide a designated area near the workplace in which employees can express breast milk in private. A few important things there: reasonable steps near the workplace and private. And importantly, private does not mean a toilet stall. Private needs to be, a separate room where they're going to be truly private from other workers, and it needs to be near the workplace. Don't know exactly what near the workplace means, but would not be sending employees, outside of the building, away from the premises, anything like that. And reasonable steps. That seems to suggest that there may be a situation out there where it's not reasonable, that you don't have to bend over backwards to do it. I made this point in the blog post. I have a hard time envisioning a scenario where you couldn't take reasonable steps to make this happen, but I'm not saying that there couldn't be. They've also built into the law an exception if it creates an undue hardship. So similar language that we see in the Americans with Disabilities Act accommodation process. Again, not sure exactly what undue hardship would be here, but it is there, and I should point it out. Final point on this new law. It requires that you provide a reasonable amount of unpaid break time to do it. Not sure exactly what a reasonable amount of break time would be, but presumably 30 minutes at least, I would think. To do that, you can, if you've already got built-in breaks for your workers, you can require that the employee use their allotted break time concurrently with that. If you've got a built-in break at 9 o'clock for the shift and the employee wants to, lactate at 10, for instance, I would not make them go at 9. I would, try to be flexible and working with them to just shift that time to 10 for them. It's unpaid break time, but you do need to be careful with how long the break is and things like that from a wage and hour standpoint. Chris, anything else on that new law that you could think of?
No, and for those employers who are required to comply with the Affordable Care Act, this was a requirement, effective 2014, 2012. I'm trying to remember the exact date. But so in regards to the time length, the Affordable Care Act gave guidance that it would be, at least 20 minutes. You say 30, I agree. And then it would be if the employee needed longer, you would let the employee sort of decide that. Very important to be flexible there. Couldn't agree more with Perry that don't make them follow a set schedule. So I'm going to hit quickly, because this was more COVID related, but I am going to just hit quickly the Supreme Court ruling on the LGBTQIA cases. And specifically, for those who are not familiar, in short, the court held that the Title VII definition of sex prohibits employers from discriminating against or harassing against anybody that's in the LGBTQIA community. And so what that means is you'll be applying your Title VII anti-harassment, anti-discrimination policies to the LGBTQIA community, your employees that would fall into that demographic, just as you would gender in your traditional protected classes. You may want to update your policies to say gender identity, sexual orientation, but the most important thing would be that you're including that in your training. And that gets me to training. So important right now, particularly the climate is very ripe for hearing from employers about their diversity initiatives and their beliefs in respecting people with differences. I mean, the Black Lives Matter movement and the SCOTUS ruling and, just a few years ago, Me Too, these should be all, warnings. It's time for an employer to really reach out and communicate with their employees about how they feel about it. Deb Sofield said, if employers don't communicate, people will speculate. You need to be communicating. And your communications need to be sincere and heartfelt. They don't need to be compliant oriented and antiseptic. I would encourage you to have forums where people are permitted to come and talk openly about things. The employers who are doing that have found so many meaningful situations, opportunities that they're permitted to communicate with their employees. And it gives the employees not only the belief, the understanding that the employer cares, but it gives them an opportunity to speak in a healthy and positive manner about how they feel impacted. Conversely, ignoring it, not mentioning it, not even addressing it at all, not responding to it, that could be a problem. Also, amp up your diversity and inclusion efforts. Think in terms of differences, not necessarily protected status. And so today's webinar is not about that. We will do one soon on that. And but I wanted to mention that now because that is a timely ruling and one that requires following now. All right, so next slide. All right, I am continuing to see employers who do not have a COVID-19 policy that covers the areas that OSHA's COVID-19 guidance said must cover. And while OSHA COVID-19 guidance is guidance, OSHA's COVID-19 enforcement memorandums where they issue citations, when they do inspections, says that if you follow the OSHA COVID-19 guidance and the CDC guidance for employers, that even if there is an outbreak or an exposure that would otherwise be attributable to the employer, OSHA will give you discretion for your good faith efforts to comply with the guidance. It's so important that employers have this guidance in place, the policy in place, and that the policy tracks the guidance. It's important that the employers have performed a hazard assessment, which means you look at the positions in your workplace and you determine whether or not any hazards exist, and you rely on OSHA's 4 different risk categories for making that analysis. For those that are medium, high, very high risk, you assign appropriate PPE. OSHA's even issued specific guidance for industries about which PPE they recommend. Find that, follow it, train on the use of PPE, store the PPE, train on how the PPE is supposed to be stored. And when employees are not following their PPE or wearing it, make sure it's addressed by your managers on the ground, your boots on the ground. This is a political situation. Wearing masks has become a political situation. It's very important that you're able to show that your managers, the ones who are dealing with your employees on, the most, are not only they're not participating in that discussion, they're complying with your policy, And they're also enforcing people wearing the PPE, maintaining the social distance, and doing the things that they need to do. You want to be able to show that in case there is an outbreak. With infections on the rise, no employer can afford the risk of not doing these things. And then finally, no retaliation. Any employee who makes a safety complaint and they're going to come, they should be, of course, transported to HR and be heard. They should be encouraged in your policies to bring forward the safety complaints. This is something OSHA recommends. These are just quick things to think about, and a checklist for you to go back and make sure that you're in the best position you can be with these rises in infections. Next slide. All right, I pulled together some very current resources for you so you'd have it. There is a handy chart that OSHA put together that details its COVID-19 guidance. And so you have that link. You also have the original COVID-19 guidance. And I have also provided I'm sorry, I had to check to see what all I put on there. I put a lot on there. Sorry about that. I provided a resource that I prepared and posted on the blog where I do an outline of the OSHA COVID-19 guidance, and then I incorporate the CDC guidance for workplaces. And the reason I did that is because OSHA in its COVID-19 guidance says that you should also follow CDC's guidance. So the middle resource there under safety compliance is one that ought to give you an idea of what everything is altogether. FFCRA leave, the Department of Labor issued field bulletins, and field bulletins mean that's what their investigators refer to when they're analyzing any FFCRA cases. They issued those, and this resource lists that as well. All right, I believe that is it, and that leaves us, I want to check to make sure that's the last slide. I believe it is, but that leaves us about 8 minutes. So y'all have been asking your questions and we've been answering them, but we didn't know if you would like an opportunity just to have a total Q&A about the things you've been dealing with and see what our answers are. Because most of the time, the questions we're getting are the very things that Perry was saying you've got to be careful about, where you have an FFCRA question or an FMLA question, but it also implicates all the traditional employment laws. And so it's an opportunity for us to address those publicly for everyone so that they can benefit from it. I'll say the most common one I'm getting is we have an infection, what do we do? And I'm finding out there's not a policy to begin with. Do the contact tracing, what does that look like? I'm getting when employees refuse to check in with the virtual health if they've been exposed, when they refuse to call the doctor even though that's what your policy says. Another one is what your boots on the ground managers are saying and what's being communicated. So, those are important things to think about. There needs to be training. There needs to be communication frequently about it. When there is an exposure, communicate with your whole community and let them know there's been a possible exposure and to keep them in your thoughts and prayers. It's an opportunity for you to let your employees know that you're concerned. Any thoughts that you would have, Perry, about the things you're seeing that are most common?
No, I think I mentioned throughout the presentation most of the things I'm seeing. Also questions about positive cases, but still a lot of leave requests and situations with employees out of work, how to pay them, when to make them come back, those types of things. So keep an eye out for those. But otherwise, no. Thank y'all for joining us today. If nobody has any questions, continue to give us feedback too. We've received a few emails directly from people, and that's great. We love to get emails from y'all. Just telling us what you'd like to hear about, or ways that we can make these better. Are they too frequent? Are they not frequent enough? Just any feedback for us on that front is appreciated. As I mentioned at the beginning, we're trying to figure out how to balance just not talking COVID to death with other employment law issues that I know are out there. So keep your feedback coming.
And I would also say keep up with our blog. We still have, it may not have felt like it through this, but we still have a practice of not blogging unless something's coming out. So if we've sent you a blog, it's not just because we're trying to waste your time, it's because there's something out there that we think you need. You know, there's a lot of COVID stuff on our blog. You could look at it as it's overwhelming. And it may feel that way, but it's also incredibly informative, and there's a lot of information there that's really more like public service announcement stuff. Free resources is what I mean, that's right there for you to use, because we really want to help y'all be compliant. So much came down so quickly, and we knew it was hard for everyone to digest. So we want everyone to stay safe. We want everyone to keep their workplaces safe and keep their employers safe. Do the things that we all need to do to protect ourselves from exposure and our employees from exposure, so that we do not have to shut down again, since that is obviously also the best way, besides keeping everybody from being infected, for us to recover financially and economically. And so we wish you all well, and continue to dream about the vacation you didn't get to have and act like you're there.
Thanks for joining this webinar presented by Hainsworth Sinclair Boyd. To learn more about the firm and its services, visit hsblawfirm.com.